Hello, Vibha ma'am. Good evening. Hello, good evening, Vibha ma'am. Am I audible to you?
Good evening, ma'am.
Hello, ma'am. I'm Gauri Gulati.
Ma'am, you're not audible actually. You're not audible.
I'm not audible. Okay, just a second, ma'am. I'll just check. Hello, am I audible now, ma'am?
Ma'am, actually, if you are not still audible, I cannot hear you. Ma'am, am I audible to you?
Yes, you are audible, ma'am. You are audible.
I can only understand your.
You are audible. I can hear you.
Okay, so, should I start?
Just a second, ma'am. I want to know from the participants, am I audible to you, participants? Anyone can unmute yourself and just answer, please.
Yes, ma'am, you are.
Ma'am.
And is Vibha ma'am audible?
Yes,
to you
ma'am.
all?
Yes, she's
ma'am.
also audible.
Okay, okay.
Hello, ma'am. Am I audible now?
Yes, ma'am. You're audible, ma'am. Am I audible to you now?
I'm still you're not audible. And like,
Am I audible, ma'am?
Hello, good evening, ma'am.
Hello, yes, ma'am. Am I audible now, ma'am?
Yes, ma'am. Now you're audible.
Okay, ma'am.
Yeah,
So,
there
ma'am,
was-
my name is Gauri Gulati and I will be moderating the session today. So, I'll just give a quick introduction and then we can start. Okay.
Sure, ma'am.
Okay. So, good evening, everyone. Welcome to the day 5 of the national level workshop, come 1 week faculty development program organized by Guru Angad Dev Teaching Learning Center, a scheme under Pandit Madan Mohan Malviya National Mission on Teachers and Training, Ministry of Education, Government of India, powered by Droit Pinel Group, a unit of Arjun Das Gulati Memorial Society. So today on day 5, we have with us Vibha Bandhu, and she's a faculty from Manipal University, Jaipur. She will be our resource person for today, and the topic for the workshop is alternate dispute resolution. Welcome, ma'am. Now, ma'am, you can proceed with the session.
Thank you so much. Thank you so much. First of all, I would like to thank the organizing committee for organizing this interactive and informative workshop. So today I'll be talking about alternative dispute resolution. So without much further ado, I would like to share my screen and start the session. Just hold on.
Yes, ma'am, we can see the screen.
All right, ma'am. Okay. So today I will be covering basically two topics. So the very first topic that I would be taking today deals with evolution of ADR and its need for codification. And the second topic that I would be taking today, it deals with international commercial arbitration as a international commercial arbitration hub. What are its issues and challenges? So I shall start the session now. All right. So the first lecture is evolution of ADR and its need for codification. So now what I would be covering in this particular topic is like the history of ADR, what it was during the ancient times, during the Britishers' time, and how it has evolved over a period of time, like during this three decade period, how it has evolved because of the different statutes. So first of all, if we talk about the introduction, we have seen that like ADR, which is commonly known as alternative dispute resolution, or in other countries, it is also known as external dispute resolution, is basically an alternative is basically an alternative to the normal litigation system, normal judicial system. Basically, it's a out of the court settlement. We are all very aware of that. Now, we often say that ADR in India particularly, we say that ADR is at nascent stage, despite of the despite of having a legislative framework, we call it as it is at a very nascent stage, and it does not have a particular very important developments which is already there in so, but if we see to the during the ancient times, we can see that ADR is not at all a new concept. This was very much prevalent for thousands of years. Like if we see the old concept of in the Upanishads, we find the mention of sort of alternative disputes mechanism. For example, if we refer to Chanakya, he gave a concept of dispute settlement in a way of Sam, Dam, Dand, Bhed, which basically resorts to a conciliator approach. Secondly, if we talk about Indian Constitution, it says that Article 142, which gives power to the Supreme Court to pass such orders which are necessary for doing complete justice. Basically, it promotes the welfare state to the people of the society. Now, so again, so if we refer to the Vedic times, during the Aryans times, they basically, since there was no written laws during those times, so it was basically they primarily invoked the unwritten laws of divine wisdom, reason, and prudence, which according to them govern heaven and earth. So we can say that yes, this was the very first of the originating philosophies of mediation, which can be put as presence of wisdom, reason, and prudence. So, and it is still at practiced in the Western countries. Also, again, after that, there was also concept of assembly, or we call it as generally as parishad or assembly, whereby there was a group of people who used to resolve the disputes of the individuals in the villages or the in the old times. So then, which at the present times we call it as basically a conference. Also, one very famous example during the Vedic times is when Yagnavalkya came up with the concept. So they were basically, he divided it into some categories. First of all, there was this category which was called as Kul, whereby the disputes between the family members and communities, tribes were resorted to. Secondly, there was another category which was known as Shreni, whereby this was a corporation of artisans who were in the same line of business. So whenever there was an internal dispute, it was resorted to by the Shreni. Thirdly, there was another category which was known as Pag, and it was again a similar association of traders in any branch of commerce. So during those times, this was a category which was evolved by Yagnavalkya in order to resolve the disputes. Thirdly, now, after that, now again, it is also a recorded fact that many of the complicated were resorted not in the king's court, but rather by the king's mediator. So there was one very famous example where two women, they claimed the motherhood of a child, and the mediator suggested cutting of a child into two pieces. So giving one half to both. So in that case, the real mother, she gave up the claim in order to save the child, and consequently, the child was given to the real mother. So this sort of example is basically, we can call it as interest-based negotiation, where the third party seeks to identify the underlying needs and concerns of the parties. And consequently, after that, there was this concept of village panchayat, whereby 5 wise men, they used to be recognized, and they were accepted as a conciliatory body to resolve the disputes. So this is how the system of alternative dispute resolution was during the ancient times. This is how it has been evolved. Now, moving forward, if we talk about the legislative framework of ADR in India, then first of all, we can see that the very first act was Indian Arbitration Act 1899. So it was the result of basically Bengal Regulation Act of 1772, which gave rise to the establishment of Legislative Council of India, which further on led to the enactment of Indian Arbitration Act 1899. Now, this Arbitration Act 1899, it was based on British Arbitration Act of 1889. Although this act was enacted, but again, it was effective only in some of the presidency towns, such as that of Calcutta, Madras, and Bombay. After that, there were many conventions which were signed. As during the very first act, it was not considered very effective. So after that, there were some of the conventions. For instance, there was this Geneva Protocol on Arbitration Clause in the year 1923, which is famously called as Geneva Protocol. And secondly, there was this Execution of Foreign Arbitration Awards 1927, that is Geneva Convention of 1927. So after India became signatory to these conventions, it further led to the enactment of Arbitration Act 1940 as a result of these conventions, and it became effective on 1st July 1940. Now, again, few provisions of the Act 1940 Act were very much problematic. The reason for that was there was very much court interference in the arbitration procedure. For instance, if we refer to Section 8, Section 11, they all allow the court for its interference in the arbitration procedure, and there was regular interference of court in the procedure, which further led to the disputes among the arbitrators and the judges. So again, this particular act was criticized for delaying the very purpose and for failing the very purpose for which the act was enacted. And again, in the very famous case of Guru Nanak Foundation versus Ratan Singh and Sons, Supreme Court observed that the way in which the proceedings are conducted under the present act, it has made the lawyers laugh and the legal philosophers weep. in view of providing a legal way that at every stage by making it as a unending prolixity because of the interference of the court. So as a result of this, now there was this Law Commission report in the year 1988, 129th Law Commission, which again advocated the need for amicable settlement of disputes between the parties. And the committee recommended that there is a requirement for courts to refer disputes to alternative means rather than opting for litigation or trials. So further, after that, after the committee submitted a report, they also made a mention of the fact that the system has to be decentralized, and it can be done by if we establish some tiers or systems within the judicial hierarchy, so that the cases can be reduced in the High Court and Supreme Court. Also, establishing, extending, and strengthening the institution of Nyaya Panchayats or some sort of other mechanism in rural areas. So this was the recommendation of this committee. And now after that, in order to improve the 1940 Act, government came up with a new act, that is Arbitration and Conciliation Act 1996. So this particular act was made to consolidate and amend the law relating to domestic arbitration, international commercial arbitration, and enforcement of foreign arbitral awards, as also to define the law relating to conciliation. So we can see how it was changed. Like initially, if we refer to the previous act, there were no such provisions. Like if we talk about 1940 Act, it basically dealt with domestic arbitrations, and again there were a lot of court interference. But in the 1996 Act, it basically, the act got divided into 4 parts. So basically, where first part dealt with the concept of domestic arbitration, the second part dealt with this enforcement of foreign awards, sorry, third part dealt with conciliation, and the fourth part dealt with miscellaneous provision. So this is how it evolved gradually through the 1996 Act. Now, after that, there was a 245th report of the Law Commission, which was titled as Areas and Backlog, Creating Additional Judicial Manpower, says that huge backlog of cases are only due to current judges' strength, which is inadequate. And the present system is not able to keep pace with the new cases being instituted, and is not being able to dispose of a comparable number of cases. So in this particular Law Commission report, which was headed by Justice A.P. Shah, they constituted an expert committee to work on this particular report, which was titled as, again, Amendment to Arbitration and Conciliation Act 1996. So again, it proposed several changes to this particular act, since there was, again, the main issue was not resolved by this particular act as well. After that, in 2015, government came up with Arbitration and Conciliation Amendment Act 2015. Now, during this time, there was a need to amend the Act of 1996. The reason for that was in order to make arbitration more popular in India, more cost-effective method of dispute resolution, because people were still not aware and people were still resorting to litigation. So the main objective was to shift the people from the court's method of dispute resolution to the speedy justice of arbitration tribunal. Now, this particular amendment, it came into force on 23rd of October 2015. And the very purpose of this act was to make countries' dispute resolution mechanism in conformity with the international standard, what is being followed in globally. So we can see the gradual development from the Arbitration Act 1940 to 1996, and then Arbitration Act Amendment Act 2015. Now later on, in the year 2016, again, a committee was formed. The chairman was Justice B.N. Sri Krishna, to look into the speedy appointment of arbitrators and to promote institutionalized arbitration, because again, there was an issue in this provision with respect to appointment of arbitrator. There was no, there was conflict between the parties, which further led to the parties moving to court for the appointment, and which was again creating delays. So in order to resolve these issues, to appoint speedily to ease the process of appointment of arbitrators and to promote institutionalized arbitration, this particular committee was formed. Also, the intention of the new amendment was to make India a center of a hub of arbitration center. And subsequently, in the year 2018, an amendment was done, but it was slapped due to the dissolution of houses. And the government again came up with the updated version of the same bill. Now, in August 2019, Lok Sabha received the assent of the president, and the intention of this amendment was to fix the loopholes which was created by Arbitration and Conciliation Amendment Act 2015. And the idea behind this amendment was to make India as a hub of arbitral tribunal, as we have already discussed, owing to the pendency of cases in Indian courts. Now, in this particular act, subsection 3A was added in the section 11, which gave power to Supreme Court and High Court that they can designate some arbitral institutions from time to time, those arbitral institutions which will be graded by the council. That is, in the new act, a new sections has been inserted which talks about the Arbitration Council of India. So to grade those, to grade those arbitral institutions, these Arbitral Council of India will be enacted, and further Supreme Court and High Court will have the power to designate these arbitral institutions from time to time. And the Chief Justice of the concerned High Court is allowed to review the panel of arbitrators whether it's appropriate or not. So again, this is a new development after the amendment. Again, one of the major acts that talks about ADR methods is the Code of Civil Procedure 1908. Now, the relevant section in CPC is section 89, which talks about, which basically which is an attempt to bring about resolution of disputes by way of ADR. And although it was initially there, but the language was not appropriate, so it was repealed by Act of 1940, and section 89 was inserted again in its current form, which was effective from 1st of July 2002. So section 89 basically talks about settlement of dispute outside the court, and it basically talks that the court, if some party approaches to the court, then court may suggest the parties, if it thinks fit, that the case is best the case can be best solved by going to the alternative methods rather than going to court. So court can suggest either the parties that they can either go for arbitration, or they can go for conciliation, they can go for mediation, or they can go for lok adalat. So this is the very important provision of CPC which talks about ADR methods. So again, after all these developments, we can see that though it got a new dimension after the codification, but still the application was very limited and there were many restrictions, which again creates an issue. So now, if we talk about the problem, like what is the reason for such conflict when there is again the court's interference at every level? So the reason is the lack of consistency in the decision, in the decisions given by Indian judicial arbitration. Like we have seen, there are many judgments which have been given, differing judgments. There are different judgments. Like still the issue of seat and venue is still like there has been so much difference in the judgment. And still this issue of seat and venue has not been very much settled. So there are many of the issues, and that is why we keep coming with the new amendments and new policies. So basically, like this was all about the particularly the Arbitration Act, like how arbitration has evolved during time. So we have seen, like from the ancient times, it was very much there during in the Upanishads, in the Vedas, and then there was, although the written laws were not there, but the disputes were resolved mainly through the way of prudence, reason, and wisdom. And then later on, after all these conventions, and we can say that India signed it way back, the Geneva Convention Conventions and New York Conventions, India signed it way back before the Singapore does. But still, when we see today, Singapore is at a much, is at a much advanced level than than India. So we have seen how ADR arbitration has evolved over time by the virtue of all these acts and by virtue of signing the Geneva Convention and the New York Convention. So, as a conclusion to arbitration, we can say that although it has been codified and there are continuous developments by way of enacting the legislations, inserting new amendments, but again, there are some issues which needs to be resolved in order to make it more effective, in order to make it a center of arbitration, international commercial arbitration, which again we will be discussing in the next topic. Now, if we talk about another method of alternative dispute resolution, that is mediation. Now, again, mediation in the current times has proven to be a very much effective alternative that is being now pursued by everyone. But when we talk about the present legislative framework with respect to mediation, we do lack that. Although, again, if we refer to section 89 of CPC, we can see that in that case, in that section, court has given the power to refer the parties to settle the matter outside the court, and one of the methods they can resolve is by way of mediation. So, talking about any judicial developments or judicial support with respect to mediation. So when this section 89 was inserted, there was this case Salim Bar Association versus Union of India, whereby Honorable Supreme Court directed that there should be a committee which can frame models explaining the procedure for mediation. So after that, this mediation and conciliation project committee was constituted, also which provides for training programs, certification to mediators, grant in aid, awareness programs. Also, secondly, the Law Commission of India, after this judgment of Salim Bar Association, they drafted a consultation paper on alternative dispute redressal and mediation rules in the year 2003. Now, this mediation rules were adopted by several high courts to formulate their separate mediation rules. So now what is happening today is the courts in Ahmedabad, the courts in Chennai, Delhi, Kerala, and Bangalore, they have annexed mediation centers within the court complexes to encourage the adoption of this particular recommendation of the court. And the courts, even at the very appellant stage, they have encouraged mediation to be a viable dispute redressal mechanism. So yes, judiciary is also in the support of advancing mediation. So this is again one of the developments in respect of this particular resolution mechanism. Now, if we talk about the legislative framework, since we have discussed the judicial support, now this is one of the issues that we do not have a particular legislative framework which specifically deals with mediation. Although there are several acts, like we can say that this particular concept of mediation is scattered in different provisions. Like for instance, if we refer to the Companies Act, there is a provision which calls for institution of mediation panel, to whom either the parties may go or the court may at any time during the proceedings refer the parties to settle the matter to the mediation. Secondly, in the year 2018, the Commercial Courts Act 2015 was amended, and section 12A was included, which provides that a suit which does not contemplate any urgent interim relief, it shall not be instituted unless the parties exhaust the remedy of pre-institution mediation. So again, this is one of a very major step which has been taken by inserting this provision, that in case if there is no urgent interim relief, it shall not be instituted unless the parties first exhaust the remedy of pre-institution mediation. Now, if we talk about in the international level, India has also showed its support for mediation as it became a signatory to a United Nations Convention on International Settlement Agreement. Further, there have been provisions which were specifically included to incentivize litigants to voluntarily choose this path. Now, for one of the examples of this is, if we refer to Section 16 of the Court Fee Act 1870, it provides for the refund of the entire court fees if the matter was finally settled using the alternative dispute redressal mechanism. So again, in the legislative provisions, though we do not have a specific law, but again, there are efforts on being made to make this process accessible and to make it basically a viable process. Also, so this is one of the problems, that despite of all these developments, India is not having any law which is dedicated to mediation. And as a mediation as a viable solution, if we refer to the example during the COVID times when the courts were forced to shut down, so those time during there was this particular instance where, if we refer to period from 215 to 221, there were around 1,869 cases which were referred to mediation by different courts, by family courts, by Tisadari courts, and out of those, somewhere around 95,000 cases were successfully disposed of, which resulted in a disposal rate of 86.56%. So this particular scenario shows that how effective mediation could be as a source of dispute resolution mechanism. And also, recently, Apex Court has directed the government to consider the practical aspects of enacting an Indian Mediation Act. So now, at present, we do have a mediation bill, but it has not been yet passed. So yes, positively, if the bill is discussed and if after the public consultation, the bill might get enacted, and we will finally have a legislative framework on mediation as well. So again, if we can formalize mediation, if there will be a law on mediation, it will help the procedure. It will help to make the uniform procedure. And if we have a comprehensive legislation, it might provide for institutionalized framework for mediation, for an appropriate body for everything, a timely disposal. We might have all these provisions under that particular act. So that is why there's a need of uniform legal framework to be adopted in respect of mediation in order to protect the rights of the parties, which might ensure speedy disposal, which might bring the provisions which are cost effective, and finally the parties can come to a settlement. So this was my first lecture on evaluation of ADR. Ma'am, hello, I'm audible, ma'am?
Yes, ma'am, you're audible, ma'am. Any questions from the participants? Participants, if you need to ask any question, you can either drop your message on the chat box, or you can unmute yourself and ask your question. Participants, any question till now?
Ma'am, should I continue with the second one?
Yes, ma'am.
All right. Ma'am, is my second PPT visible?
Yes, ma'am, it is visible.
All right. So Since we have already discussed the evolution of ADR from the ancient times to the present times, how it has evolved, we have seen that because of all these legislative frameworks and all the continuous amendments, we have grown from what we were back during the previous times. But still, the current topic will deal with how India can be considered as an international commercial arbitration hub, but what are the issues and challenges that we are lacking behind? Why we are still not able to create India as a center for international commercial arbitration hub? So now, when we are talking about international commercial arbitration, now what gave rise to this concept of ICA? So basically, we have seen that how today trade commerce is not limited to a particular region or a particular society or a particular country for that matter. Rather, the trade has been crossed the borders, and today we see a continuous increase in the international trade. Now, when there's a global trade at a global level where multiple countries are involved, it is inevitable, the disputes are inevitable. So in that case, it gives rise to a concept which we today call as cross-border commercial disputes. So now, in this cross-border commercial disputes, when there is a when the companies are involved in a business, now if there is any conflict, if there is any clashes, parties, if they go to court, again it will be a very time consuming process, very cost taking, time taking, which will further lead the companies to to a huge loss. So today, international arbitration again has emerged as a preferred option for efficiently resolving such sort of cross-border commercial disputes and preserving and saving their business relationships. So that is why the need of international commercial arbitration arose. And recently it has grown, like especially after the COVID and everything, after the thing, after the technology, since everything is virtual today, since everything, like there is no need of people to go to the physical location, since everything is connected digitally today. So there is more and more rise in the international trade, and which is further giving rise to the cross-border commercial disputes. So that is why there's a need of international arbitration in order to resolve all these disputes and to save the business relationships. So also we can see that how Indian this India is rising. India is being party to many international trade. So that is why India's role in this sector becomes very much important. Now, if we refer to the decisions given by Indian judiciary in the last 3 decades, particularly in the cases involving foreign parties, the Indian judiciary was criticized because of its interfering approach, as we have already discussed in the first lecture, that how initially the acts that were enacted, they basically inserted provisions whereby more of court interference was there. So in all those judgments, in all those decisions, we can see that the Indian judiciary was criticized first for its interfering approach and also for its extraterritorial application of domestic laws in foreign seated arbitrations. But again, there have been developments as well, whereby we can see the different approach of courts during the present times and the executive. So now in the recent series of judgments, we can see many of the decisions of the Supreme Court are pro-arbitration, which have again changed the scenario of the arbitration landscape in India. Sorry. Now, from the period of 2012 to the current period of 2022, we have seen that Supreme Court has delivered various landmark rulings, be it declaring the Indian arbitration law as a seat-centric, or be it referring the non-signatories to an arbitration agreement to settle disputes through arbitration. Like there were many case laws which initially said that if someone has not signed the agreement, they cannot be referred to an arbitration. But now again, in the recent judgment, court held that even the parties are non-signatories, but they are considered as an important party which affects them, then they can resolve their disputes through way of arbitration. So more of a liberal approach, we can say. Also, giving recognition to orders of emergency arbitrator. Now, initially there was no such concept, but and also in the previous judgments, the court was not court did not recognize this concept of emergency arbitrator. But again, in a very recent judgment, it was court was more in favor of in one of the cases, court was in the favor of this emergency arbitrator, that in case if the parties do not have that time to appoint the arbitrator, in that case they can seek the help of emergency arbitrator, which is this kind of practice is also prevalent there in CI, that is Singapore International Arbitration Center. And also decisions relating to narrowing down the scope of public policy objection in context of domestic and foreign seated arbitration, and clarifying the various nuances of the arbitrability of disputes. So again, initially, if we refer to the previous cases, now there were issue in the concept of public policy, like court had many of the awards of arbitrator as against the scope of public policy. On that ground, that award was set aside. So initially, the approach to public policy was very much wide, but now during the recent judgment, since the court has realized that this is creating issues, and this is very much defeating the purpose of the Arbitration Act, and it is also like, because of this particular issue, the foreign investment is getting hampered. So from 2012 to 2022, we can see how the judgment has been changed by bringing all these concepts, like declaring the Indian arbitration as a seat-centric, referring non-signatories to an arbitration agreement, and giving recognition to orders of emergency arbitrator, and to narrow down the scope of public policy objection in context of domestic arbitration and foreign seated arbitration, and clarifying the nuances of arbitrability of disputes. So again, this is one of the developments. Sorry. Now, the Indian legislature and executive have taken measures again to bolster the concept of ease of doing business in India, and to clearly reflect a pro-arbitration policy that can be seen from the enactment, from the amendments that are continuously coming up, and from the judiciary, from the support of the judiciary, how they are taking a pro-arbitration how they're giving pro-arbitration judgments. So since this we have already discussed, that Arbitration Amendment Act came in October 23, 2015, which was very well received, and which came up with very significant changes. But again, there were a new committee to bring in the new act. So since we've already discussed that there were the committees, B. N. Sri Krishna committee, which came up with this act, and which further led to amendment in 2015 and further in 2019. So now, again, in the year 2020, on 4th of November 2020, the Arbitration and Conciliation Amendment Ordinance was promulgated to further amend the Arbitration and Conciliation Act 1996. So again, after 2015, after 2019, in the year 2020, again there was ordinance was issued in order to insert some of the provisions. So subsequently, the 2020 ordinance took shape of the Arbitration and Conciliation Amendment Act 2021. So that is how we can see how legislature is continuously endeavoring to improve the arbitration landscape by bringing in continuous amendments. Now, again, going back to the meaning of international commercial arbitration, like if we refer to the Arbitration and Conciliation Act, it is defined under Section 2(1)(f) of the Act 1996 Act, and it defines international commercial arbitration as an arbitration relating to disputes arising out of a legal relationship which is considered commercial, where either of the party is a foreign national or resident, or is a foreign body corporate, or is a company, association, or body of individuals whose central management or control is in foreign hands. So basically, in order to put it in a simple language, international commercial arbitration where one of the parties involved is of a foreign resident, or the company involved is of a foreign resident, or where the central management or control is in foreign hands and one party is Indian, that is considered as international commercial arbitration. Also, the important point to note here is that under Indian law, an arbitration where the seat is India and where the party, one of the party is a foreign party, that will still be regarded as international commercial arbitration, since one of the parties is a foreign resident, and though India have chosen the seat of arbitration as in India, but still it would be considered as an international commercial arbitration. Another point to notice here is that all arbitrations, the seat of which is in India, including international commercial arbitrations, they are subject to part 1 of the act. So as we have discussed in the previous lecture, that as this arbitration act is divided into 4 parts, whereby the first part deals with domestic arbitration and domestic arbitration and ICA, and the second part deals with enforcement of foreign awards. So here we are talking about the applicability of part 1. So all arbitrations, whether they are seated in India and including ICA, so whether it's a domestic arbitration where both the parties are Indian or where one of the parties is of a foreign resident, in that case part 1 will be applicable. Again, we have cases on this particular issue that we've like there was this Bhatia case, and then this Balco judgment, which discussed about the applicability of part 1, where so initially in the initial cases it was held that part 1 would be applicable irrespective of whether the seat is India or not. But after the post Balco judgment, it was held that part 1 would be applicable only on the arbitrations which are seated in India and ICA. And where an arbitration is seated outside India, the part 1 act would not apply. However, there are certain exceptions to it. For instance, there is section 9, section 27, and section 37 that might still be applicable in case of foreign seated arbitration, as these are the provisions which needs court assistance, and they are considered as exceptions to make the process more accessible and easy. So unless the parties have excluded these provisions will applicable on the international arbitration as well. Now, if we see international arbitration through judiciary, again, we have seen that continuously India is working to advance the culture of international arbitration in order to compete with other countries, obviously. And in November 11, 2021, the government issued a new notification, which is known as Arbitration and Conciliation Amendment Act 2021, which again repealed the ordinance of 2020 and which paved the way for promotion of international commercial arbitration. So in the series of judgment, one of the very important judgment, Sundaram Finance Limited, it was held that the award holders might now initiate execution actions before any court where the parties' assets are situated. So this is one of the legal major developments, as there was again conflict in the previous judgment whereby there was issue where there were different judgments of the court, whereby some of the courts said that award holders has to the execution actions can only be initiated in a court which has the jurisdiction, or but in this Sundaram Finance Limited, it was held that award holders might now initiate execution actions before any court where the parties' assets are situated. So basically, this was one of the legal developments. Major developments, and same kind of view was supported in another cases of Dalem Industrial Company Limited and Tata Motor Finance Limited and others. Now, again, in the 2015 amendment also, there were notable developments in order to promote international commercial arbitration, which again, and because of which people have now some sort of confidence in resolving in resorting to ADR procedures. Now, coming to the issues of international arbitration. Now we have seen that how every country today aspires to become the center of arbitration. Now, what is the reason for that? There are many benefits which it entails. Now, one of the a very major reason is that every country wants to get more and more of investment, but before investing, the investors would take note of different factors, like for example, whether the country has a robust arbitration mechanism, whether the courts and government of that country are arbitration friendly, or whether there is ease of doing business and stable environment. So these are the major factors which the investors consider before investing in any country. Now we have to see, because of all these factors that we are lacking in, that India is unable to still become the international commercial arbitration hub, unlike all the other countries. So now one of the major issues is also this, that today we have ad hoc arbitration rather than having a institutional arbitration. So this is also one of the major issues because of which we are lacking behind. We do have ad hoc arbitrations, but we are moving gradually towards institutional arbitration, but yet it has not been properly implemented, we can say. Although again, government has taken many steps in that direction. So again, like we have already referred that under the new act, section 43A to 43M is there, which talks about establishment of Arbitration Council of India. So again, but the problem with this particular provision is setting up of Arbitration Council of India. Now it says that the members of that Arbitration Council of India will be members from the government, and it is advised that these councils should be there should be less control, and it should not be controlled by the government. So that is again one of the issues with the council. Now we have to see what are the major prominent issues because of which we are because of which India is unable to be at the center stage of becoming this international commercial arbitration hub. So the very first problem is the very first issue is with respect to availability of full-time arbitration lawyers. So what happens is, lawyers, they often give second preference to arbitration matters, and they choose the time slot after their court hours for conducting arbitrations. And already, like after the court hours, they many a times it happens that they seek adjournments and they fix the dates in arbitrations, so when they do not have any hearings in the court. So this is one of the issues. And so this is one of the issue where arbitrators, where they are unable to give sufficient time to the arbitration proceedings. So the very first issue is, there is a need for full-time arbitration lawyers and the arbitrators who can devote more and more time to arbitration, so that there are no delays in the arbitration process. Another issue is the drafting of the law. The drafting of the law needs to be very clear, needs to be very unambiguous. So if we refer to the amendment of 2015, there was this section 34 of the Arbitration Act. It was basically an invitation to file objections and automatically stay the operation of arbitral award as soon as the petition under section 34 was filed. So it was a very problematic provision that as soon as you file a petition under section 34, as soon as you challenge the arbitral award, the award would automatically stay. So that there was an automatic stay of the arbitral award as soon as the petition under 34 was filed. So this was one of the major hurdles in executing the arbitral awards. Although this issue was addressed through the amendments which was made to the 1996 amendments, but the language was not clear, and because of that language, it was such that it took somewhere around 3 years to understand whether the Amendment Act applied to pending section 34 petitions or not. So in case also, the judicial time got wasted to give clarity to those amendments. So this is the second issue, that the drafting of the law is very much problematic, we can say, whereby the language is not clear. So that is another area we need to work on. Another issue is lack of proper law. So since we have discussed that there has been continuous bills and the government is continuously bringing amendments after amendments, which somewhere shows that the issues are not properly addressed and the amendments are not properly drafted. That is why we are continuously changing the provisions. So like section 36 of the 1996 act, section 36 raises several concerns, because again it provides for unconditional stay on the operation of award in case if it is find out that fraud or corruption is involved. So again the issue is, it would again take us to the time where there was automatic stay of arbitral award, because it will give time to the judgment debtors that they can avoid their obligation of the award. So also there is the provision is not clear that what constitutes fraud or corruption, because it has not been defined under the 1996 act. So it might lead to a situation where after every award, the judgment debtor, he can allege that there has been fraud and corruption, and he might get an unconditional stay on the operation of the award. So as a consequence of this, the enforcement of awards will get more difficult, and consequently the ease of doing business will be very much affected. So this is again one of the major issues. And another example, if we see, is section 29A, which is contrary to the idea of section 5. Section 5, which talks about that there will be minimal interference of the court, but section 29A is again where the court comes into picture, and where there is extension of time period is given. So again it might take more than that. So again that is one of the issues in this particular law. Another issue is lack of institutional arbitration. So at present we have some good centers like Delhi International Arbitration Center, Nani Palkhiwala Arbitration Center, Mumbai Center for International Arbitration, but still India does not have any sort of institution that can be considered as par with Singapore International Arbitration, or for that matter London Court of International Arbitration or International Commercial Court. Now, so we have to see the reason, that what is the reason that we are lacking behind, and these institutions, they are gaining a lot of momentum. So the reason is, first of all, most of the arbitrations in India are ad hoc, that we've already discussed, and which is one of the major reasons that why arbitration mechanism in India is not robust. Now, also, there is a need of a renowned arbitration expert. If we talk about Singapore Arbitration Center, it is led by Gary Bond, and we can see how effective it is, how systematic approach the center follows. So, but again in India, owing to the busy schedule of litigation lawyers in India, it is very unlikely that any leading lawyer would thoroughly engage with an arbitration center. So again, we do lack institutional arbitration, which is a very much need of the hour today. Another issue is judicial intervention. So that again is a very relevant, very relevant issue of judicial intervention in every aspect of the arbitration, which ultimately defeats the purpose of the alternative dispute resolution. So again, section 34 example, we've already discussed that how it can, if someone challenges the arbitration award, how it can take forever to decide the matter. And also what happens is, one of the major issues that has been seen is that when an appeal is filed in the various courts, now Supreme Court has given a clear direction that when the matter goes under section 34, you cannot go into the merits of the case. But many a times we have seen that the court have again reappreciated the evidence. They have permitted the counsels to argue the merits of the case at length. So that is also one of the major issues, which again hampers the effectiveness of this particular mechanism. Sorry. Another major issue is practice of appointment of retired judges as arbitrators, as we have seen that the arbitrators are overburdened with arbitration because we do not have options to choose from. Now, what is the reason for that is that we are not letting the young arbitrator lawyers to be appointed as one, and as a result mostly the retired judges are appointed. Now one of the recommendations is that this practice should be done away with, and the young lawyers should be appointed as an arbitrators as disputes. It will make this particular whole mechanism as more effective, and the quality of awards will also not suffer. So now also if we compare it to the other countries, they have not this practice of appointing only the retired judges as arbitrators like India follows. So this is again one of the issues. And another issue is inadequate representation of the arbitration issues. So for that, we need an arbitration bar. So if we talk about the Bar Council of India, Bar Association of India, now they do not speak about the issues related to arbitration. Why? Because they're too busy dealing with the inefficacies of the court. So this is also one of the major reasons why the issues relating to arbitration mechanism are not properly addressed or highlighted. So there's a need to have a bar to address the prevailing issues and the concerns of the arbitration practitioner. So if we have one institution like that, it can further make the approach a very systematic and formal, and in that case it can be one of the effective sources. Another is the approach of the arbitrators. Like in a tribunal, like we under this particular act, there is section 19 which specifically provides that you do not need to follow the rules of evidence and CPC. Now, many a times in our tribunal, there is this arbitrator who strictly follows these provisions, the procedural laws of evidence, as opposed to the section 19, which again defeats the whole purpose of this particular act. So in this case, the arbitration merely again becomes the just like a civil suit. Also, they do not control the cross examination. So now in that case, what happens is lawyers keep asking on unnecessary and repeated questions, which eventually delays the arbitration processes immensely. So again, there is a need of arbitrators to take the control on the cross examination, and they should not permit questions that are based on contents and interpretation of documents. Another issues which are faced during arbitration proceedings is absence of professionalism and mannerism. They do not have a proper, they do not have proper guidelines or ethics and duties to follow. So again, because of that, there is no particular like we do not have any particular guidelines for ethics and for duties of arbitrators. So again, we suffer from that particular difficulty, such as absence of mannerism and professionalism. Then another reason is problems posed by the public sector undertakings. So many a times public sector undertakings have this tradition of not settling the matter and to contest till the end. So in that case, the government should direct the ministries to analyze that what cases should be contested and which should not be. And if it is find out that award is a recent one, then it should not be challenged again and again. So this is again one of the issues. Another is again that we have discussed, the government interference. So if we compare, if we talk about other countries, there is the institutions there, they are not government controlled. For example, ICC, CR or LCIA, they are not government controlled. But if we talk about India, the New Delhi International Arbitration Center and the Arbitration Council of India, they have members from the government. So again, this will depend a lot on the functioning of like Arbitration Council of India and the how government will interfere. So because it is advisable that the interference of government should be least, should be minimal in arbitration matters. But again, when the members are of government, then it might again create a problem. So how it will work, that would be an issue. So these are the major problems which I find and which are creating barriers for India to become an international commercial arbitration hub. And so now, after going through the whole scenario of alternative dispute redressal mechanism, right from the evolution to the present acts, and to the efforts of the judiciary in coming up with the proactive pro-arbitration approach, and the efforts of the government, we can see that arbitration in India today is considered as an unruly horse, because at sometimes it moves forward, at sometimes it moves backward, and sometimes it moves sideways. So again, we can see that though there's a significant growth of arbitration, but again there are few points that we need to we need to take care of. So sorry, there are few factors which are need to be taken care of: ease of doing business, enforcement of contracts, and execution of arbitral awards are some very important factors that might help a country to attract the investment and to further make that country effective for to make that country a particular preferred option for the parties to go for alternative dispute mechanism. And uh, again, when the awards are considered, when the awards are well reasoned, they should not be challenged by the parties. Also, as the officers of the court, lawyers should not resist arbitration, or they should not file frivolous challenges to the award in order to resist the enforcement. And effective enforcement of awards would further help in making arbitration more robust, more effective in India. So it all depends on, like, if the countries, the foreign companies will only invest if they see that in India the option is viable, they can easily resolve the it will not take much time, it will be cost effective, and more importantly, the award will be enforced effectively. So if all these factors are complied with, India, nothing can stop India from becoming an international center. So again, it will, if all these conditions are there, it will attract more investment, and which will prove to be beneficial to the economy as a whole. Also, one more thing that I need to cover is that at present also there's lack of awareness in general public about choosing arbitration over the court. Now, for reason if that is, unlike in Singapore and ICC, India do not hold conferences. So there is need of more awareness campaigns to be introduced in order to educate the society, to tell them the benefits of resorting to this mechanism. And all the members of legal fraternity, they should be trained, they should be encouraged to step in as a full-time arbitrator lawyer. There should be centers for training, there should be these mechanisms whereby students and lawyers are more keen to resort to go to practice as arbitration lawyers. And apart from this, major important thing is that we need less judicial interference, and we should, like, in this particular recent amendment, there was one provision, one schedule which dealt with eligibility of the arbitrators. So in that case, one of the points was that he should be an advocate practicing in India. So again, although again, as a welcome step, that particular schedule was deleted. So we need to welcome the foreign lawyers to come and do arbitration in India. So if we follow, if we learn from all these countries, especially Singapore and ICC, we can see that what all they have done to be at the international commercial center, and what practices we can follow in order to be the one. So I hope that is all from my side. And with this, I would like to end my topic lecture.
Any questions from the participants? Participants, you can unmute yourself, or you can even drop your question in the chat box. Any questions from the participants? Yes, ma'am, I think there are no questions from the participants. So we will end this. Thank you so much, ma'am. It was a very informative session. Thank you for sparing your precious time for us and for the participants also. So thank you so much, ma'am.
Thank you, ma'am. Thank you so much, ma'am.
Thank you.